Hello, and welcome to Tenants and Neighbors, a live call-in program about tenants' rights. If you're a tenant and you have a question about your rights, or if you have a question about a problem that you're having with your landlord, or if you have a question or a comment about any of the landlord-tenant laws or any of the goings-on in larger society, you can call in right now and get an answer to your question or a discussion right here on the air. My name is Michael McKee. I'm a tenant organizer, and I'm one of the founders of the New York State Tenants and Neighbors Coalition. Tenants and Neighbors is a statewide membership organization that advocates and lobbies for tenants' rights in affordable housing and mobilizes our members and supporters in pursuit of those goals. Throughout the program and at the end of the hour, there will be information about how to get in touch with tenants and neighbors, as well as many other useful sources of information and assistance for tenants. These will appear on the bottom of the screen as we go along. My guest is Michael Kozek of the tenant law firm Jeffrey S. Wiener & Associates. Welcome, Michael.
Thank you, Michael. It's my pleasure to be here. Thank you for having me as your guest.
Sure. What kind of cases does your firm deal with?
We are generally a litigation firm in real estate. We handle all aspects of real estate litigation. In landlord-tenant matters, we are tenant advocates only. We do not handle landlord cases. We generally deal with all types of landlord-tenant disputes, holdovers, non-payments. We deal with various aspects regarding various aspects of the law regarding landlord-tenant relations.
Holdovers meaning eviction proceedings.
That's precisely right. We deal with rent stabilization laws. Quite frequently, there's litigation over whether an apartment is rent stabilized or not. Another area that we focus primarily on is the New York State loft law, which affects really only tenants in New York City, in Manhattan, and in Brooklyn.
The loft law, and of course with the new loft law of 2 years ago, I would assume that there's been a lot of action and a lot of developments, and you probably have a lot of people coming to you for advice and information.
That's very true. For the first few months after the amendment to the loft law was enacted, tenants were slow to assert their rights until
people didn't know.
People didn't know, yeah. and they were not entirely comfortable with asserting their rights against a landlord without knowing for certain whether or not they would be successful. Now we're seeing that more and more. In Manhattan, it's not as prevalent because there aren't as many residential conversions of commercial space. This is
Manhattan. The loft units in Manhattan have, by and large, been legalized by now.
That's right.
30 years down the road after the original loft law was enacted.
That's right. It was originally Tribeca and Soho that was affected, and now you're talking about areas like Dumbo and Williamsburg, where you see something similar to what happened in the 60s and 70s. Where artists moved into commercial or non-residential spaces and converted them to residential use. So the new loft law gives them a means for legalizing their units and then bringing them under the rent stabilization regime.
Do you find that landlords, as a rule, are complying with the new loft law amendments, or are they resisting this, or is it a mixed bag, or what?
It is a mixed bag. There are some that realize the benefits of it, and that ultimately failing to comply is not going to work out to their advantage. The quicker that they process their buildings through the loft law process to bring them into code compliance, the quicker they can collect rent. If they are resistant to that, then there are some penalties in the loft law. Primarily, the primary penalty is that if they don't comply with their legalization obligations, they cannot collect rent from the tenants of these illegal units.
So we're talking about, to bring these up to code, we're talking about things like fire safety, code compliance. These are not residential units. These are basically commercial or manufacturing units that have been converted illegally to residential use, or in most cases combination residential and workspace. So the landlords are required now to put in provisions like sprinklers or whatever that would make them safe for people to live in.
That's right. All of the building code aspects that would apply to illegal residents apply to these buildings. And so that they have to be taken from the non-residential use, which is, generally doesn't include kitchen facilities or the type of plumbing facilities that you have in a legal residential building, or, as you say, the fire safety concerns are one of the main issues that the landlord has to address in this process. There's various other issues such as egress and ventilation and the like.
Because many of these units only have one means of entering or exiting the space, there's not a second way of getting in or out.
That's
which
right.
can be a concern with fire safety.
Fire safety is a significant issue, and it is. There are a few steps that the landlord has to take to bring these buildings into code compliance. The first is they have to file an application to legalize the building, and this is all done under the auspices of the New York City Loft Board, the administrative body that oversees the loft law. So they have to file their permit, then they have to get approval from the tenants of their plan to legalize the building. The reason that the loft law requires that the tenant involvement is that oftentimes the tenants themselves were the ones that did much of the work to make these units into residences. So the loft law gives them an opportunity to participate in the process and to allow for these units to be brought into a state that conforms with their own desires for how they would like to use the buildings.
In the beginning, once these amendments to the law were passed and the Bloomberg administration opposed them very strongly, I heard reports that the city was not being very cooperative. The buildings department, the loft board were being really very difficult and were not seeking to help implement this new law. Has that changed?
It's changed a bit to the extent that they're now beginning to implement the regulations, and they understand that there really is no resisting the effect of the law. They have to process the applications.
It is the law.
It is the law, after all.
Whether Mike Bloomberg likes it or not.
The one issue, as is an issue with many of the administrative agencies dealing with housing in New York City, is that there's just not enough manpower. At the loft board, they have a flood of applications now, and they're just taking a long time to process them.
Yeah.
And that leaves the tenants in a vulnerable situation because in reality, we're talking about buildings that are unsafe for residential occupancy.
Right. In fact, many of them, the city has come in and put in vacate orders and made people leave.
Yeah, and that's precisely the problem. If you have a building, if you have the Department of Buildings issuing vacate orders against tenants who have a legal right to be there under the loft law, and the loft board is at the same time failing to process these applications, then you've got a conflict between the two administrative agencies.
And it goes without saying that to do this successfully, tenants need to organize and they need to work as a group through a tenants association, because they're going to be much more effective if they do that.
We emphasize quite a bit with many of the people that come to us that they should do this as a group process for a number of reasons. One of the main reasons is the economic reality of having to hire a lawyer to deal with this process. You don't only need a lawyer, but you also probably need an architect as a tenant, because you want to have an expert look at what the landlord is proposing and to be able to give expert opinion about whether that is sufficient to meet your needs and to come up with alternative plans. So to defray the cost of that, it often makes sense for the tenants as a group to come together and do it as a group. Additionally, there is the persuasive effect of a tenants association coming as a group. It puts a landlord in a position where they understand that they are dealing with not just one person, but many people who aren't simply going to
go away,
be idle. Yes.
Right. Great. All right. Well, with that, we will take a phone call. Hello.
Yes, hello.
Hi, you're on the air.
How are you?
Okay, and you?
I'm doing fine. I live in a Section 8 building, and recently there has been a great press in regards to inspecting apartments. And, you know, sometimes I try to duck this and whatnot just to get out of it. But, you know, recently over the past month, I allowed the inspectors in because I don't necessarily have anything to hide. And one of the inspectors, my question is, he opened my closet. And I told him, you know, I closed the closet. You're not supposed to be looking in my closet. You're supposed to inspect the apartment, anything damaged and whatnot. And I was told I was being uncooperative. And they left. I thought they were going to come back at another time. That's one question. And the second question is that this inspector came in my house with a computer. And if they were going to come back, I was going to disallow this because, you know, computers have cameras. It was open, and I don't know what he could have been jotting down and whatnot. And I'm not going to allow anyone in my apartment with a camera to view whatever I might have in here. Again, I'm not saying I have anything illegal in here, but I think I have the right to deny, you know, someone taking pictures in my apartment. And the third thing I want to ask is that if someone is, like, say, living in a cluttered situation and they are now disabled, what can that person do? Again, same Section 8 building. Could they, you know, allow the management, give the right the management to throw out whatever in there because I don't, you know, this person doesn't need to be sat out. They're disabled. And what rights might that type of person have?
Okay, just a couple of questions. First of all, you say this was an inspector. Do you know where the inspector was from? Are you sure of that?
HD, I have
HPD?
here, but I don't have it right at hand.
Showed you a badge or showed you some identification?
Well, the super came with them, the super of the building.
Okay.
So the two of them came in, and the super went one way, and the one gentleman with the computer, the guy I didn't recognize from this agency, he was the one that opened my closet, and then.
Well, we got all of that. The question is, how do you know that this was an official inspector from a city agency?
Well, I'm assuming. So
that might not be a reasonable assumption. You might want to ask for identification next time.
Oh, okay. Well, fine. Well, see, the super was with him. The super of the building, I know.
Well, that's fine. That's neither here nor there.
Okay, fine. All right, understood.
Okay. Jeffrey, how would you, Michael, how would you advise the caller? What about the closet? Is there anything structural that they could be looking for in the closet?
I can't imagine.
I can't imagine either.
It sounds to me like this. Caller, are you there?
Yeah, I'm still here. I'm listening.
Just, were you given any information about what the purpose of the inspection was?
Well, the inspection, you know, it hasn't changed as far as I know for over the, you know, 15 or so years I've been here. They came here, you know, basically looking, you know,
housing
at the
quality
fixtures,
inspection.
any damages, you know, leaky ceilings, that type of stuff. And nothing more than that. Nothing about, you know, just inspecting to see if there's anything damaged that they could, you know, maybe charge you for to have repaired or something like that. Bars on the windows, that type of stuff. And it has nothing about, you know, going into closets because I've had these inspections before and never has my closets been opened.
Well, I would say to you this. The closet is obviously an element of the apartment. And if they're doing a general inspection of housing conditions in the apartment, you know, that would include molds, any kind of vermin, insects, and
right.
And those
see like water or, you know, maybe some water damage, you know, let's just say outside the closet or something like that, that would, you know, say, well, we need to look at this further. Well, okay, that I can understand, but, you know, everything in here, there's no damage, no foul smell, no vermin or anything like that. I don't have anything like that in my apartment. So I just got, you know, incensed because, again, I've gone through this before.
I think it's really a gray area. I mean, that's my view. I don't see how, there's probably not a rule one way or the other, I would guess, but I think you're quite within your rights to prevent somebody from taking pictures. I mean, sometimes landlords send people in and they say they're inspectors, and what they're really doing is fishing to see how well you keep house.
Right,
And they'll
okay.
take pictures and see if you're cluttering, and if you're a messy housekeeper and you've got stuff piled up or whatever.
Well, I don't have a situation like that.
No, I'm not saying that you do.
Okay.
I'm just saying that's what sometimes landlords are
Right,
doing.
right.
But I think you're certainly within your rights to say no pictures.
Right.
Yes,
right.
I would agree with that. That the no pictures insistence on your part would be correct.
Right, and I don't know, because all I just saw, and this was after they had left, I had realized that this guy had an open computer. And I'm like saying, well, next time, thinking that they were going to come back, and there may be a tomorrow, again, a year or so from now, and I just, wanted to ask you gentlemen these
Well,
particular
inspectors do often use computers to record violations or whatever.
Right, right.
So it depends on what the computer is. I mean, obviously, if it's a camera, that's one thing. So this was like your annual housing quality inspection.
Yeah,
is that what you think
that,
it was?
Yeah, that type of stuff.
Right.
And like I said, I've been through this before. You go through the apartment to look, look at, the ceilings, and this specifically, I think, is looking for any type of damage. If this is broken or if this needs to be repaired, and that.
Well, to qualify for Section 8, the landlord has to keep the apartment in a good habitable state. So
right, and the smoke detectors, those
Right.
type of things they want to look at. And again, I have no problem with that. But again, this gentleman was walking through. Well, he began to before we got into the disagreement about the closet. He had a computer, and I'm like saying to myself, next time that's not going to be. You're going to have to shut that down. And I mean, if there's anything that you want to record, the super had pad and paper. You could write it down and, determine it from there. Now, the third thing, I don't want to monopolize the call here, is that someone who's living in a cluttered condition, the same building, and they're now disabled. What can that person do, or what should be, what type of advice you could give?
I think in general, if somebody is a victim of this illness, cluttering disease or hoarding disease or whatever you want to call it, you need professional help. And the fact that the person is disabled wouldn't in and of itself protect the tenant from some kind of action against the tenant. So I would find out, does the tenant have a social worker, for example? If he or she is disabled, then likely there's some agency or some private organization or some government agency that you could turn to for help. There are any number of resources for resolving these matters and bringing professional people in to help get the apartment squared away, which is a much better result than being evicted.
Right.
So that's how I would approach that. Do you?
Okay.
How would you?
I would agree with that. I think just to add on to that, if the tenant, the disabled tenant, is willing to participate and allow people to come in and clean up the cluttered apartment, and it's not clear if this is a collier or a hoarding situation, but if it is, it may form a basis for a nuisance eviction action, and the tenant obviously in that situation would rather, ideally, have the situation taken care of. So if the tenant is willing to allow the landlord to come in and
that's sometimes a big if.
That is a big if, but perhaps a landlord would be willing to do that under certain conditions.
All right. Well, I think I'll try the social work avenue first.
I would deal with that end of it first, and then not worry about the landlord until later.
I agree.
Oh, okay.
I agree with that. Yes.